The legal earthquake we've been waiting for just hit. The Supreme Court has officially moved to an emergency footing on a case that doesn't just tweak gun laws. It could literally abolish firearm permits in all 50 states. We aren't talking about shall issue versus may-is issue anymore. We are talking about the complete end of government permission slips for your Second Amendment rights. And the biggest shocker, the Trump Department of Justice, led by Attorney General Pam Bondi, just threw the full weight of the federal government behind it, filing a brief that goes further than any federal government position on gun rights in American history. If you want to understand how the map of America is about to be permanently rewritten, you need to hit that subscribe button right now. This case is moving at light speed, and if you live in a state that still requires a permit to buy or carry, your life is about to change. Here's what stunned the legal community. 3 weeks ago, a coalition of Second Amendment organizations filed an emergency petition with the Supreme Court that did something nobody expected. They didn't ask for a hearing next term. They didn't request the normal appeals process. They demanded an immediate emergency review on whether states have any constitutional authority to require permits for firearm ownership or carry whatsoever. Within 72 hours, what makes an emergency decision different? The Supreme Court didn't just agree to hear the case, they granted it emergency status and moved it to the front of their docket, leapfrogging over dozens of other cases that have been waiting years for review. Usually, a case takes 3 to 5 years to crawl through the system. But the Supreme Court just bypassed the line. Why? Because they've recognized a constitutional crisis. Right now, 27 states have constitutional carry, meaning you don't need a permit. But in the other 23 states, including giants like California, New York, and Illinois, you are still required to ask the government for permission before you can exercise a fundamental right. The court has decided that this zip code-based version of the Bill of Rights can no longer stand. The petition itself is only 47 pages, remarkably short for a Supreme Court filing, but every single page is packed with devastating arguments. The lead attorney told reporters they deliberately kept it concise because the constitutional argument is actually very simple. You cannot require citizens to obtain government permission and pay fees to exercise a fundamental right. Period. They point out that nobody needs a permit to go to church, to speak their mind, to vote, or to hire an attorney. So, requiring a permit to exercise Second Amendment rights treats that amendment as a second-ass right. But here's where the real power of this case comes in. The petitioners didn't just make theoretical constitutional arguments. They brought receipts, real-world data from 27 states that have already eliminated permit requirements. And guess what happened? Crime didn't skyrocket. The blood in the streets, predictions from gun control advocates never materialized. In fact, the opposite happened in most cases. Arizona eliminated permit requirements in 2010, making it one of the earliest adopters. DOJ's role and why it's significant in the 13 years since, their violent crime rate has dropped by 11%. During the same period, California, which maintains one of the strictest permit systems in America, saw violent crime increase by 8%. Texas went constitutional carry in 2021, and their murder rate dropped 6.88% in the first full year. Tennessee implemented constitutional carry and didn't see the Wild West chaos the critics promised. Instead, their violent crime rate dropped by a staggering 7% over the next 2 years. The petition includes data from all 27 constitutional carry states, and the results are consistent. States that eliminated permits saw either stable crime rates or decreases, while many permit-required states saw increases. But it gets even more devastating. The petition cites FBI data showing that in permit-required states, less than 0.3% of crimes involving firearms are committed by people who went through the legal permit process. That means 99.7% of gun crimes are committed by people who never bothered with permits in the first place. This completely destroys the argument that permits prevent dangerous people from getting guns. Now, here's where it gets truly unprecedented. Attorney General Pam Bondi and the Department of Justice filed a brief that didn't just say overly restrictive permit systems are problematic. They argued that the entire concept of requiring government permission to exercise Second Amendment rights is fundamentally unconstitutional and must be struck down immediately. The brief opens with a statement so direct it's been quoted in every legal publication covering this case. The United States government takes the position that requiring citizens to obtain permits, pay fees, or seek approval before exercising their Second Amendment rights violates the Constitution in the same way that requiring permits to attend church or obtain approval before publishing a newspaper would violate the First Amendment. What changed right away? Let that sink in. The federal government of the United States just told the Supreme Court that permit requirements are unconstitutional. Not sometimes, not when they're too restrictive, always under any circumstances. The DOJ then delivers what legal experts are calling a knockout blow. They cite a 1915 Supreme Court case that explicitly held that making constitutional rights contingent on fee payments is unconstitutional because it allows government to price rights out of reach for poorer citizens. The brief includes financial analysis showing that in permit-required states, the total cost of obtaining a carry permit ranges from $200 to $700 when you include application fees, training courses, fingerprinting, and photographs. In some jurisdictions, the costs exceed $1,000. But the Trump administration didn't stop there. They included something that has anti-gun states absolutely terrified, a proposed remedy. If the Supreme Court rules that permits are unconstitutional, the DOJ is requesting that the court immediately enjoin all permit requirements nationwide. We're talking about instant constitutional carry in all 50 states the moment the decision is issued. No grace period, no transition time, immediate effect. If you thought the DOJ's involvement was a game-changer, wait until you see the scale of the state-level uprising happening right now. Every single state that has already adopted constitutional carry has filed briefs supporting this petition, creating the largest state coalition backing a Supreme Court case in modern history. We're talking about 27 states representing 47% of the American population, all telling the Supreme Court that their experience proves permit systems are unnecessary for public safety. But here's the kicker. This coalition just filed arguments that use a weapon the anti-gun lobby never saw coming. They aren't just talking about rights. They're talking about class warfare and economic discrimination. The state coalition, led by heavyweights like Texas, Florida, and Tennessee, is arguing that permit requirements are inherently discriminatory. Think about it. If how permit systems could be affected live in a high-crime neighborhood and you're working 2 jobs just to make ends meet, can you really afford a $150 permit fee? Can you afford to take 2 days off work to attend a $300 mandatory training course? Tennessee's brief focuses on exactly this. They point out that before constitutional carry, obtaining a permit cost $165 plus $75 for the mandatory training course. In a state where 30.4% of the population lives below the poverty line, this represented a significant financial barrier. After eliminating the permit requirement, firearm ownership among lower-income residents increased by 22%, while violent crime in lower-income neighborhoods actually decreased by 9%. Missouri took a different but equally powerful approach. Their brief provides documentation showing that Missouri's permit system was originally enacted in 1921 specifically to prevent black citizens from arming themselves during a period of racial violence. The brief includes quotes from legislators at the time explicitly stating this purpose. Missouri argues that modern permit systems, even if not intentionally racist, still have disparate impact because they give officials discretion to deny permits. And studies show that black applicants are denied at rates 2 to 3 times higher than white applicants in may-issue states. This argument is a tactical masterstroke because it forces the liberal wing of the court to confront the fact that permit laws disproportionately disarm low-income and minority communities. The states are arguing that these permission slips create a financial barrier that targets the most vulnerable citizens, essentially turning the Second Amendment into a luxury item for the wealthy. Now, this is the part where the Supreme Court was basically forced to step in. It's called a circuit split, and it's currently creating a country where your constitutional rights depend entirely on your GPS coordinates. The Fifth Circuit ruled that permit requirements violate the Second Amendment. The Ninth Circuit ruled the exact opposite just 6 months later, holding that permits are constitutional. The Second Circuit has upheld permit to purchase requirements. Who may feel the impact? First, the Fourth Circuit has upheld Maryland's extensive permitting scheme. This means that someone living in Texas has a constitutional right to carry without a permit, while someone in California can be criminally prosecuted for doing the exact same thing. When you have one part of the country saying something is a right and another part saying it's a crime, the Supreme Court has no choice. They cannot allow the Bill of Rights to be optional depending on which state line you cross. Legal scholars are calling this the clearest conflict in decades. The momentum is undeniable. The DOJ is in. Half the states in the country are in. The data is in. It looks like a total victory for the Second Amendment is on the horizon. But there is a massive wild card in play. While we're focused on the Supreme Court, the anti-gun states are working behind closed doors on a secret strategy to make sure this ruling never actually takes effect. Multiple sources inside state legislatures have confirmed that anti-gun states are preparing a coordinated strategy to avoid compliance if the Supreme Court rules against permit requirements. California legislators are drafting emergency legislation that would technically eliminate their permit system, but replace it with a mandatory firearm safety certification program. Same background checks, same fees, same training requirements. They'll just call it something other than a permit. Illinois is exploring a liability insurance requirement. They might say, sure, carry without a permit, but if you don't have $1 million insurance policy that costs $500 a year, you're a felon. It's a permit requirement disguised as a financial regulation. New Jersey is looking at a system where you don't need a permit for the gun, but you need a government-issued ammo ID for every single box of ammunition you buy. These states are betting they can stay one step ahead of the Supreme Court by changing the vocabulary of their restrictions while keeping the burden exactly the same. But does the Supreme Court see this coming? All signs point to yes. In the DOJ's brief, Pam Bondi didn't just target permits. She argued that any system requiring government pre-approval or the payment of a fee to exercise a right is unconstitutional. If the Supreme Court adopts that broad language, these backdoor schemes will be common assumptions and misinterpretations dead on arrival. So what's the timeline? Oral arguments are expected to be held in March or April. This is when we'll hear Justice Thomas and Justice Allo grill the state lawyers on why a right requires a fee. The final decision, we're expecting the hammer to drop by the end of June. This means we are only months away from a potential nationwide permitless America. Based on the emergency status, the massive state and federal support, the clear circuit split, and the composition of the current court, the likelihood of permits being struck down is extremely high. Legal scholars are putting it at 75 to 85%. This would represent the most significant Second Amendment victory since Heller recognized the individual right to bear arms in 2008. If you live in one of the 27 constitutional carry states, nothing changes for you. But if you live in one of the 23 states that still requires permits, the next few months are absolutely critical. If you've been putting off getting a permit because of the cost or hassle, you might want to wait. The decision is expected by late June, just a few months away. Start paying attention to what your state legislature is doing right now because they're almost certainly already working on alternative restriction schemes. This is a turning point in history. You cannot afford to be out of the loop. If you want to know the second the Supreme Court releases a new order or Pam Bondi drops a new brief, you have to be subscribed with notifications on. Drop a comment below telling me what state you're in and whether you think the Supreme Court will actually have the guts to end permits nationwide, or if states like California will find a way to dodge the ruling. I'm keeping my eyes on the docket every single day, so you don't have